Many clients ask me a very difficult and emotional legal question. If a person is suffering from a terminal condition or is lying in a vegetative state with no hope of recovery, can the family legally stop life support in India? Let me explain how Indian law deals with the sensitive issue. First, we need to understand what euthanasia means. Euthanasia is commonly referred to as a mercy killing. It means ending a person's life in order to relieve unbearable suffering caused by a serious medical condition. In law, euthanasia is usually discussed in two forms. The first is active euthanasia, where someone directly causes the death of a patient, for example, by administering a lethal injection. The second is passive euthanasia, where doctors withdraw or withhold life sustaining treatment and allow the patient to die naturally. Now, many clients are surprised to learn this. In India, active euthanasia is illegal, but passive euthanasia is permitted under strict safeguards. This position was recognized by the Supreme Court of India in the landmark constitutional case of Common Cause versus Union of India in 2018. In that judgment, the court held that the right to die with dignity is part of the right to life under Article 21 of the Constitution. The court also recognized something called a living will, which allows a person to state in advance that if they become terminally ill or permanently unconscious, they do not want artificial life support to prolong life. Later in 2023, the Supreme Court of India simplified the procedure for living wills so the patient and families could exercise this right more practically. Now, let me come to the most recent development, which is extremely important. On 11 March 2026, the Supreme Court of India delivered a landmark decision allowing withdrawal of life support in a real case involving a patient in a permanent vegetative state. The case is involved Harish Rana, a young man who had been in a vegetative condition for nearly 13 years after a serious brain injury. After examining medical reports from expert boards and considering the emotional plea of his parents, the court allowed the withdrawal of life sustaining treatment, applying what is known as the best interest principle. This was historically significant because it was one of the first direct application of the passive euthanasia framework laid down by the Supreme Court. The court emphasized that continuing artificial treatment in a situation where recovery is impossible may only prolong biological existence without dignity. The court also reminded the government that India still does not have a comprehensive euthanasia law and urged the legislature to consider framing one. So, what does this mean? From a legal perspective, Indian law today tries to balance three very important principles: the sanctity of life, the autonomy of the individual, and the dignity of the patient. Active euthanasia remains illegal. But when medical experts confirm that recovery is impossible and legal safeguards are not allowed, withdrawal of life support may be permitted in order to respect the patient's dignity. As a lawyer, I always advise clients that if they want their medical wishes to be respected in such circumstances, preparing a legally valid living will is extremely important. It gives clarity to doctors, guidance to family members, and protection under the law. Questions about life, dignity, and law are never simple, but understanding your legal rights helps families make informed decisions even in the most difficult moments.